Today we are talking about nominating guardians for your minor children. Here are just a few of the comments that I hear from people about guardianship. I already have godparents named for my children. Isn't that enough? My parents will take care of the kids if something were to happen to me. I don't know who to pick, so I'm just not going to worry about it. Stick around and I will explain how to nominate guardians for your minor children and things that you should consider. Hello, thank you so much for joining me for Estate Planning 101 series. I am the estate planning mom and my name is Krista Hermans. I am an estate planning attorney licensed in California, and I help families with minor children protect their children and families through estate planning. Please make sure to click that subscribe button and hit that bell to be notified when new videos are released every Monday. And if you didn't see the first video in the series, head over to see what probate is and grab the free emergency contact sheet I'm giving away there. Today we are talking about nominating guardians for your minor children. So what exactly is nominating guardians for your minor children? Well, it's the process where you put in a legal document who you would want to raise your children if you or the other parent's child were not able to raise them. To do this, you could either put the guardian nomination in a will, and if you didn't see where I went over the wills in the second video in the series, please go back there and check it out. The other one is doing a nomination of guardian form. When I work with clients, I generally do a long-term guardian nomination form as well as a short-term guardian nomination form. And what this does is it allows clients the ability that maybe they have a guardian that isn't local, or they don't have any family around, or maybe the guardian is in another country. Having the guardian nomination form, the long-term one, allows them to choose whoever they would want to be guardian, or the short-term actually says people that are close by that they're giving permission to hold temporarily until the actual guardians are able to arrive. And this is really big with clients that I have that maybe move here for a spouse's job and don't have any family around, so they're able to identify friends that they've made in the area that if something were to happen to both of them, they would have people that are legally identified to be able to take custody of their children, to prevent the children from ever having to go into child protective services until a guardian was actually able, or a family member was able to get to the children. So some of the benefits of nominating guardians for your children: it allows your wishes to be known in case something were to happen. The court wouldn't have any idea who you would want to raise your children, and this piece of paper essentially is you saying, these are my choices, this is who I would want to raise my children if I was unable to. It also allows you to identify alternates in case your first choice isn't available. And when I work with clients, I generally ask them to identify at least one primary guardian, as well as identifying 2 alternates, so that they have a large selection if something were to ever happen. So some of the cons of not having guardian nomination is kind of what I touched on before, is if you don't have the guardian nomination, a court would decide who would raise your children, and they would have no input from you on who you would like to raise your children. So don't forget to click that subscribe button and hit that bell, and please comment with any estate planning questions or comments that you may have. Thank you.